All rise. Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Patricia J. Millen presiding.
Please be seated. We have one case today. Andrew Thompson is the employee. The employer is Minnesota Trial Courts, District 4, and the insurer self-insured is the state of Minnesota. This is with number 19328-606, date of injury December 27th, 2001. I have attorney Joshua Harrison on behalf of the employee.
Yes, Your Honor.
Thank you. And I have Michael Courtney on behalf of the employer insurer.
Your Honor, I'm Lucas Craig on behalf of the employer insurance statements.
I'm sorry.
Lucas, Lucas.
Yes.
Last name Craig, C-R-A-H.
Thank you. Well, as you both are aware, oral argument is streamed live. So our audio visual tool has one microphone. Our microphones are turned off. So having said that, we ask that you speak up and we'll make sure that it's being caught on the recording tool so that we have access to that at a later date if needed. But each party has 15 minutes to present their position. You can reserve time if you wish at the beginning. And are you both familiar with the tools here at the Minnesota Judicial Center regarding oral argument? Great. I won't go through it then. Mr. Thompson's attorney, Joshua Harrison, you have the floor. Thank you.
Thank you, Your Honor. I would like to request 2 minutes for rebuttal. May it please the court and good morning. My name is Joshua Harrison and I represent appellant Andrew Thompson. Mr. Thompson comes before this court today to ask you to reverse the administrative law judge's decision and hold that his injuries that were sustained in December 2021 are compensable under the street risk doctrine, the special hazard exception, as well as the special errand exception.
Mr. Harrison, I have a question for you right away.
Yes, Judge.
Those are all exceptions to injury to an employee that occurs on the premises. Can you explain to me why we're into an exception and not just looking at an injury that happened on the premises of the employer?
Yes, Your Honor. Those are exceptions to the coming and going rule, whereby traditionally when an employee is not on the premises and is instead on the way, typically claims are barred. However, these are 3 classic exceptions which can provide coverage under the workers' compensation.
And in regard to the premises, is it your position that once the employee crossed the street from where he parked and was on the South Plaza or Government Plaza of the Government Center, that where he fell was not on the premises of the employer?
Yes, Judge. We argue and agree that this was a public sidewalk. And unlike static and other cases where when an employee is directed to park at a specific location, such as an employer-provided parking lot, the trip from that parking lot to the premises can be considered the premises as well. This is instead a case where, because Mr. Thompson was performing services for his employer, encountered a special hazard that was causally connected to his employment, and because the preceding work day, he had been assigned tasks which required both an outgoing trip, a task to be performed, as well as a return trip. He had not yet completed that return trip when he fell on the public way. Your Honors, the street risk doctrine was adopted in 1993 in Hansen versus Northwestern Fuel Company. It was later affirmed 3 years later in Booken. Under that doctrine, if an employee is performing services for their employer, and that service entails the use of a public way, it is compensable under the Act.
What do you think is your strongest argument for an exception here?
Yes, Your Honor. The clearest and cleanest exception is the street risk doctrine, Your Honor. It's very clear cut. You look to see, was the employee performing a service? Then you look to see, if the employee encountered what's known as a street risk. Street risks are very broad. They can encompass stray animals, uneven pavement, motor vehicles. In one case, it was even referred to as policemen shooting at fleeing felons. Then you look and see, did that street risk cause the injury? If the answer to all three questions is yes, then the injury is compensable. It arises out of and in the course and scope of employment.
So what services was your client providing to the employer?
Yes, Judge. He was providing the service of transporting equipment. On December 23rd, 2021, the verdict in the Kim Potter trial was set to come in at, I believe, 1:30 to 2 o'clock. Prior to that verdict coming in, Mr. Thompson received explicit instructions from the employer to pack essential equipment and transport it to a location of his choosing to continue performing services for them. Later, he received an instruction to return to the government center the next workday. He understood those instructions to instruct him to return that equipment he had been explicitly required by the employer to transport off-site. Your Honors, transporting items from one location to another is a classic service. It's some people's entire job description. Entire industries and businesses do solely that. Here, Mr. Thompson did not routinely transport equipment home. It was not his choice. It was not his practice. It was not for his convenience. It was solely at the instruction of the employer. At hearing, the employer provided zero evidence for how else that equipment was to be returned to the premises. There was no text, email, Slack message, anything providing any other way that equipment was going to get back to the government center. The only evidence presented at hearing was Mr. Thompson's testimony that he understood his instructions to be to return the equipment.
Let me ask you a question. So he fell on an icy sidewalk, as I understand it.
Yes, Judge.
And so the only increased risk that he would have, as apart from the general public, is the fact that he was carrying equipment then, which was incidental to his employment at the time that he fell.
There wasn't necessarily increased risk that he would experience from the general public. However, under the street risk doctrine, as held in Bookman, as well as Locke, as well as Hansen, there is no requirement for an increased risk with the street risk doctrine. If the employer is providing the service, to a certain degree, that was the employer's choice to send them forth from the premises and encounter risks. And if they are injured, that is the employer's responsibility under the Compensation Act.
And so if I understand your argument, from the minute your client started walking away the day before the injury, his whole travel leaving, including his drive home, and then likewise his whole travel the next day, carrying the equipment that he was required to take home, carrying the equipment that it had to be brought back, he's covered.
Yes, Judge. Well, especially under the traveling between workplaces doctrine the day of, on the way back, it could be considered the street risk doctrine. Also, the totality of the instructions he was given created a special errand as well, which I'll address later.
Mr. Harrison, I have a question. It is the employer's position that you're basically opening the floodgates here. If you allow for the equipment, especially in this day and age where you have cell phones that you're using for your work activity, computer laptops that you're constantly using, how is that different from what happened here? How can you distinguish that?
Yes, Judge. This was, as I mentioned earlier, not his convenience. This was not regular. This was not repeated. This was explicit instructions related to a very specific event that originated on the employment premises. Respondents' argument that somehow this is opening the floodgates for the street risk doctrine simply does not have basis in the Minnesota Supreme Court precedent.
Counsel, I'm going to stop you there because the employee was subsequently informed to return to work, finding 7 unappealed as normal. To lock every entrance to this building, is that normal?
He was instructed to return at the normal time and that work would resume at the government center. It would no longer be remote. When they sent him home on December 23rd, it was unclear whether or not the verdict would result in an arrest or other issues, which could
That wasn't made clear in the finding. It says the employee was subsequently informed he was to return to work as normal. Are we to interpret that only to the actual time
Yes, Judge,
and
because
not as to the entrance or anything else?
yes, Judge, because if you look in the order, which I can pull up, you will see
Okay.
that it was found that the security measures
Mhm.
remained in place. Those
Right.
security measures were no skyways, no tunnels, no parking at site, and only one entrance located in the building.
So counsel, I guess my question is that normal?
No,
It doesn't seem normal to me.
not at all, Judge, you're correct. There was still significant disruption to ingress and egress from the premises. Your Honors, the case that's most on point here is Locke v. Steele County. In that case, an employee had standing instructions to go retrieve her employer's mail from a postal office that was close to the courthouse where she worked. She began that route on a public sidewalk when she fell on ice and was injured. The employer in that case argued, we're not responsible for these injuries because at the time she fell, her commute route to work as normal was identical to the service route. There was no deviation. The Minnesota Supreme Court considered that argument and explicitly rejected it. They held that the route is not what matters. The employee does not have to show they would be at a different place at a different time, or really anything was different. They just need to show that something that was in the employer's interest was being advanced by them proceeding down that walkway.
Counsel, would you agree though that this is different than Locke in that in Locke, she was going to the mailbox on a lunch break, she would go home for lunch, she then went to the mailbox and then would bring it up. The facts here are different in that the call to the street is what I will describe it as, was actually on December 23rd when he was asked to leave with the equipment. The return route was different than stop and get the mail and then come up.
No, Judge. When he was instructed to return to work, he understood his instructions to be return to the Hennepin County Government Center with the equipment. There was no provision made for any other way for that equipment to be returned. Of course, it was going to be returned the exact same way it left the government center on the 23rd.
All right, but there was discussion, and it was mainly in closing argument, where the employer brought up, there was no instruction to bring it back. And in fact, there was other equipment that your client could have used at the employer on that day. So I understand what you're saying. My client figured, I got to bring the stuff back, but there's no evidence that he had to. Does that make a difference?
No, Judge. She was complying with implicit instructions, which is recognized by the courts as being perfectly valid. Most of what employees do in a given day is implied. If I ask the paralegal to file a claim petition, I also am asking them to have it notarized, to have it served upon the appropriate parties, to save a scan into the file. Here there was the implied instruction, which he complied with. And if there was any evidence the employer wished to present that his understanding was incorrect or some form of communication was sent to him, making that incorrect, they could have presented it. They did not, because that was the obvious implication in how the employer intended that equipment to get back there.
So, counsel, I'm understanding you to say that this really hinges then on the email that specifically said, bring any equipment you need home with you. Had the email just said, be out of here by noon, would that be different in your argument at all? Would we be talking about a different exception?
Yes, Your Honor. So if the employer on the day the verdict was to be released said, for security concerns, we are ending work for the day. Go home, go wherever you want. We'll inform you when the next work day is. There might not be a case at all, Your Honors. But instead, the employer chose to continue to try and extract labor from their employees, including Mr. Thompson. When they instructed him to travel to a secondary location, they knew without a shadow of a doubt he would have to face street risks. And likewise, he would have to face them when coming back. Your Honors, I would like to briefly address SATIC, which respondent cites. SATIC was a case that you inquired about earlier, Judge, where if you park at an employer-provided facility, well, that's what the employee asserted, where if you park at an employer-provided facility, the travel between that place and the premises can be considered the premises. However, the street risk doctrine was never asserted in that case. So the court's denial of compensability in that case really has no bearing on this one because the street risk doctrine wasn't even invoked. Another case that provides compensability, Your Honors, is Snickers v. Finger Hut. In Snickers v. Finger Hut, there was an employee who worked at a building with only one entrance and exit. Fellow employee emptied a drink on the sidewalk. That drink interacted with Minnesota weather to turn into ice. That employee then fell on the ice. And the court held that because that ice was causally connected to the employment premises, it constitutes a special hazard. Here, the trial was causally connected to the security measures. The security measures restricted all entrances and exits down to one. And but for that trial, Mr. Thompson would not have had to encounter ice because, as was testified to, he always took the skyways during winter. Your Honors, Mr. Thompson's injuries are compensable under the street risk doctrine, the special hazard exception, as well as the special errand exception. He asks that you reverse and remand for further proceedings. Thank you.
We're going to ask you I'm going to ask my colleagues if they have any additional questions.
Thank you.
Oh, and actually, sorry, thanks. Just as you thought you were done. My question is this, and this has to do, you were talking with the case where the coworker threw the drink on the sidewalk.
Yes, Judge, Snickers v. Finger Hut.
So, but you would agree that that was part of the employer, because it was a coworker that caused the hazard.
What seemed to be the crux of the matter, Judge, was that ice was causally related to the employment premises and something taking part thereon.
In your case, what was the hazard?
The hazard was the potential for unrest and violence because of the Kim Potter trial, which clearly necessitated the security measures, which were still in place on the day of injury, which prevented him from having a safe method of access, which caused him to encounter ice. It's a little bit longer of analysis than the street risk, but it's still there.
And I would have thought that the hazard in your case was the ice on the pavers, but you're saying the hazard was actually the security situation.
The ice was the hazard that caused the fall. Having to encounter it was causally connected to employment through the security measures.
But regardless of how we define hazard, neither situation was caused by the employer.
Correct, Judge. Yes.
Thank you.
Thank you.
Hey, good morning. My name is Lucas Gray. May it please the court of counsel. I'm here on behalf of the respondent, state of Minnesota.
I ask you to speak up.
Usually I have the opposite problem. So I think we've had a good discussion here so far. Obviously, this case has a lot of very unique factual issues here. But I think at the end of the day, we really cannot find these exceptions that are being urged by the appellant in this case here. And I think it's important to recall that on the morning of December 27th, the employee is in a public area on Hennepin Government Center Plaza. This is not property that is owned or maintained by the state of Minnesota.
Doesn't that box you in pretty narrowly? Let's start on December 23rd.
Sure. And I think that is part of the, all the factors we have to look at here. I think he was, and I think Judge is correct to point this out in his findings in order, had the injury occurred as he's leaving his normal place of work, his normal hours of work, possibly on a different route, that may have fallen into the special errand exception. And I think when we look at this here, I think the idea that there's this highly attenuated special errand that stretches across multiple days and the return leg is happening now on December 27th, I think that's too attenuated. I think his special errand was go to a different location, continue work. As of December 27th, his orders were return to work as normal.
As normal would have been him using the Skyway, correct? And that was his normal course,
That was his choice.
was it? He had no choice on the 27th.
Right, that was his standard, but I think from the employer's perspective, normal means your normal work hours, your normal place of work. And that's exactly what's happening. He has to take an alternate route due to decisions that the state of Minnesota did not make. These safety measures weren't put in place by Hennepin County, who is effectively the landlord for the employer in this case here.
Can I ask you a question? The stipulations for fact, all of them except for two, basically deny liability. I felt like I was reading a negligence case. Is there a reason why the stipulations from 3 to 10 were about no accountability, no control, no uncertainty, or no certainty?
Right, and I think that does go into our discussion about the special hazard exception here, and as was discussed in the briefing here, this is a narrow exception, can only apply if the hazard originates on the employment premises. In this case, the employment premises are the 8th floor of the Hennepin County Government Center, not the outside plaza.
And let me stop you there. So your position is the employment premises he has to be on the floor in his office when the injury occurs.
I think that would be correct. At this point, the public plaza leading to the door is no different than the parking ramp across the street. These are orders owned and maintained by third parties.
So, but regardless, the only way to get into that building at the time was to traverse the South Plaza.
Correct.
And the only way then to enter the secured area on the North Plaza, which I believe was where the security entrance was, would have been to encounter the North Plaza, go through the security door. Still wasn't on the employment premises at that time, according to your theory. True?
Correct. This is a different public property owned and maintained by a different entity. This is no different than if there had been road construction and caused them to take a different commute route in to get to work that day.
So he goes through security, enters the atrium between the courts tower and the administrative tower. And I believe that the employee worked in the courts tower. Is that fair understanding?
That's my understanding.
So he's there, he's in the elevator, he's still not on the employment premises. It's not till he gets to the 8th floor and in his office.
I think that's the area that has at least a measure of control by the state of Minnesota versus Hennepin County. So I think at this point, he's still on a second party's area here. And I think this is important. We do have the Snickers v. Finger Hut case here. This was one where the special hazard did emanate from the employment premises. A coworker threw a frozen drink out on the only way out of there. In this case, there's nothing anybody at the state of Minnesota did to create both the method he had to use to approach the building as well as the black ice itself, which was just...
All right, but the employer leases the space from the county. The state leases the space from the county. The county controls the entirety of both plazas and the entire building. Why isn't this just an ingress and egress case then? Because the employer doesn't have to control the ingress and egress for injuries occurring during ingress and egress recovery.
That's a great question, Judge. And honestly, this is not one that I think was argued or briefed here.
Well, it clearly wasn't argued by anybody, but rising out of was argued, and ingress and egress encompasses a rising out of. Can we look at ingress and egress?
Judge, I'll be honest, I can't tell you one way or another standing here right now. So I don't want to give you an answer without having given it some thought.
Okay.
And
I guess I'd follow up on that. The premises arising out of and in the course of working premises. I think your analysis is very narrow. Unless I airdrop the employee, he has to enter in that door at that time to get to the 8th floor. And I don't understand why, if you look at old pieces, the place is not actually used on the strict course of employment, have been held to be working premises in the past. At what point, don't you think that's just too narrow of an interpretation to say anything outside the 8th floor, but the only way you can get here is by using that entrance on that day at that time?
My immediate response to that is that those are factors beyond the state of Minnesota's control. Their landlord is the one who put these issues in place. I think this is more analogous to the Maker v. Kelly Law Registry, where someone is on a public sidewalk very close to the workplace employment premises, but not in, and has not actually begun any work activities at that point, and is injured on that sidewalk and was found not to have a compensable injury from that event. And so I think that's probably the better analogy from here.
Mr. Craig, counsel for the appellant states that the street risk doctrine is most compelling and strongest argument. I'd like you to address that argument, that doctrine.
Yeah, thank you. And I think the crux of this case is whether, in fact, he's carrying a briefcase at the time this happens that contains some work materials, turns this into, he's essentially doing work activities at this point rather than being on his way into work here. And I think has been pointed out, I think we need to look at whether or not this is a distinction that actually makes a difference. It sounds like had he simply forgotten that briefcase that morning, there's alternate things he could have done. From my perspective, he is on his way to do a normal day of work, his normal hours of employment, his normal work activities, happens to be carrying this briefcase, which he wouldn't be normally. And I think when you look at the street risk case, they are on a specific task, delivering mail to a post office, things like that. I think in this case, this is someone who's simply on the last leg of this morning commute and unfortunately had an accident.
So why would that be a completion of the duty that he had on the 23rd when he left? It was in the employer's interest for him to pack up, bring everything with him, his work, etc., and work in a different location. Then why wasn't it also in the employer's interest to have him return with that equipment?
I think it probably wasn't the employer's interest. I think one of the things here is that there is no presence of the briefcase had no material impact on this injury occurring. It didn't cause him to fall. It didn't aggravate his injuries, anything like that. I think also if we can look at some counterfactuals where he doesn't have that on him, could there have been alternate arrangements made? Possibly, is he able to get through his workday on the 27th without that material? Yeah, it sounds like yes, he could have. So obviously that stuff needs, like all employer property needs to get home at some point. And I do think from a big picture here, in the year 2023, a lot of people are taking laptops to and from home to work. We're checking our work emails on our cell phones. I think there is a risk of overexpanding. You have something somewhere on your person that you've used for work at some point in time. At the time you're injured, that could expand into a very broad category of claimed injuries where we haven't seen that so much in the past.
Although, would it make a difference when the employer actually asks that employee to pack up the equipment and go versus somebody who just voluntarily says, yeah, I think I'm going to bring my computer home, see if I can work a little strictly?
I think it's something to be taken into consideration, but I think there is a risk of an exception swallowing the rule at some point as things are getting more and more these days.
Mr. Craig, in looking at the stipulations and the findings in order of the judge, was there a determination of factual finding made by the compensation judge detailing or describing the employment premises of the employee in this case?
Judge, I don't believe so without taking a look at those findings in order right here, right now, but I don't think that was really delineated in the findings in order that came down from Judge Martin.
And then looking at the memorandum, which is an explanation of the findings, where the judge notes there might be a stronger argument that the employee had been injured while he was leaving on the 23rd during the workday at the request of the employer instead of coming back to work. And I guess just theoretically in my own mind, I have a hard time, okay, you get sent out and then you're coming back and it's the same. borrow from Boys Council, the errand or special errand or the trip that was requested by the employee coming back as opposed to going. Can you help me out?
Yeah, and this is a tricky one. I think what Judge Marshall is saying is when you're sent away from your normal place and hours of work in the middle of the day with work equipment with you, that I think that probably certainly was a special errand. I think the question is, when does that special errand terminate? And I think the more practical approach would be is that terminates essentially once he's done getting to a secondary location and finished doing his work at that secondary location, versus a several days later coming into your normal hours and place of work. I mean, things as normal, as I think is correct. And I guess I would also point out that we need to take a look at what was the hazard here. When we're using a street risk analysis, the hazard is black ice. But what the appeals urging is for the special hazard analysis, the hazard is not black ice. The hazard is a trial that has potential for unrest and this kind of whole domino chain leading to him coming back to that particular entrance that morning here. I do think, I was thinking back.
Is that a distinction of merit? I'm a little puzzled by that. If he can't use the Skyway and there's no ice in the Skyway and it's safer for him to go forward in that method, but he's prohibited from it, he has no control over that. The fact that there's ice then 70 feet, 70 yards, we're not quite sure. Does that matter? Is that a distinction of merit?
I think it is, because we're talking about decisions made several days previously. The risk that was imminent on the 23rd was some kind of unrest. Government center has to shut down, something like that. That's not what manifested. That's not what caused any injury here. Had there not been freezing rain that morning, perhaps this injury wouldn't have happened at all. And I think we're just getting so far down this domino chain. Butterfly flaps its wings in Brazil, it was a typhoon in China a month later, kind of causal link here. I think it's just too far attenuated. I think if the hazard, I think any reasonable person will look and say, well, the hazard's black ice.
So you don't even think it's reasonable?
I don't think it's reasonable.
The complexity of this argument.
I think it's just too far attenuated. I think every other case we've looked at, Snickers v. Finger Hut, the hazard was the thing that caused the injury directly, frozen sidewalks.
Mm-hmm.
And I think that's what we should be looking at here as well. So I think the special
All right,
hazard.
so let's say we do.
Okay.
That's the hazard, the black ice. We ignore Mr. Harrison's argument that the hazard was the potential for unrest. That's the black ice.
Right.
He encountered it because it was the only way in the building. Because he wasn't allowed to use any other way to get there other than to walk on icy sidewalk. Was all of the sidewalk icy everywhere? Who knows? But it was icy in that sidewalk in the box of the Hennepin County Government Center area. That's the hazard. Only way in or out. Why is this not covered?
Well, I think it doesn't meet special hazard exception. We have to have a hazard that emanates from the employment premises.
Okay.
And I think that's meant in a much more direct and kind of physical way than kind of this false graph type proximate link.
Does it mean a street risk then?
I think the street risk is probably the more viable exception here. And I think for reasons that hopefully I've covered here, I don't think street risk is applicable, as he's not specifically doing a work task for the employer right now. He's simply on his way into work.
Mr. Craig, again, getting back to the special hazard, we've been kind of jumping around a little bit, so I appreciate you tracking with this. But again, assuming that the ice is the hazard, was Mr. Thompson situated differently than anyone in the public in relation to that hazard?
I don't think so. I think anybody else who was going in to renew their driver's license in the downstairs driver services bureau would have encountered the same hazard in the same way. So I think that's another reason why the special hazard exception is not applicable here. Street risk says you don't have to be at a greater hazard than the general public that point. So I think that's the.
Well, then jumping back to the street risk, isn't it true that he brought the equipment, Mr. Thompson brought the equipment home at the instruction of the employer?
He did.
I have another, I'm a little puzzled here. Is there an error of law here? I mean, based on, do we remand it?
I
Or do we reverse, or do we affirm?
well, obviously I would like you to.
I'm asking you seriously.
Yes.
I would like you to address why we wouldn't remand, why we wouldn't reverse, why we would affirm.
Well, I think we have a well-founded decision from Judge Marshall here. I think he's seen all the evidence this time. He's had a chance to consider the arguments on these exceptions. His accompanied memorandum, ideally, maybe that would have been a bit more fleshed out and that would have avoided some of this discussion here today. But I think at the end of the day, I think what he's saying is the special errand ends on the day that he leaves, essentially, once that workday is completed. I think he doesn't find the street risk to be applicable, and I think for reasons we've been discussing here, I think the special hazard's not applicable either. That's really, I think it should be allowed to stand here. I think Judge Marshall has the most complete view of all the evidence at this point.
Yeah, questions? Thank you.
Okay, thank you.
Well, I know you both went over the 15 minutes, even though you had reserved 2 minutes. We would allow, if you want to, each of you another minute if you need to respond.
Yes, I would enjoy rebuttal, Judge.
Okay, you can enjoy it.
Don't love what you do, but
Let's make a knowledge of it.
We'll give you each 2 minutes.
Your Honors, opposing counsel concedes that a special errand was likely created when he was sent home on December 23rd. As the Minnesota Supreme Court held in Langston, a special errand begins from where the employee leaves during them completing the task and only ends when they reach the portal to the place where the special errand began. If a special errand was set out per Youngberg and Benston, it did not end until he reached the portal of the government center, which he did not do before he was injured. As to the opinion, with all due respect to the administrative law judge being well-founded, opposing counsel has not argued for any of the rationale in that decision being dispositive here. They no longer do the, well, we don't know where they would have been if they parked somewhere else. He's not arguing that any of the rationale in the majority of the decision holds. Your Honors, he also argues that, well, the employer didn't have control of what happened outside of the government center, and that should be a reason to deny compensability. It's the exact opposite. The reason why the street hazard risk, the special hazard exception, the special errand rule all exist is because when an employer sends their employees out into the broader world, interacting with the public, interacting with weather, they are at greater risk than they face in a controlled indoor environment. That's the very reason why all these various doctrines exist, is because they have to encounter those risks. The employer made the choice to send their employees home and continue working and encounter risks. They could have ended work for the day, and if they had, we would not be here. But Mr. Thompson was completing the tail end of a special errand, which is well established in law. And I would just note, for purposes of the special hazard, in Snickers v. Finger Hut, the drink was not a danger to the employer until it interacted with the outdoor environment and froze into caramel-colored ice. That's what caused the injury. So there is a causal chain in Snickers as well. It originated on the place of employment. It then went outside. It then interacted with weather. The causal chain was not broken by weather in Snickers. It should not be broken in this case either. Thank you.
Oh, I'm good. Is it okay?
Oh,
Thanks. We're kind of talking about special errand
yeah.
work for the first time, and I agree with you. I picked up on that as well. But you agree that for special errand to apply, you have to show that the errand was outside of normal work hours.
There appears to be two types of special errands. There appears to be the type of special errand considered in Youngberg, and then there appears to be the special errand referred to in Swanson v. Swanson. And if there's already two, there might be three, there might be four. The exceptions to the coming and going rule are flexible. They understand that work occurs off premises, and when employees are asked to face hazards, they should, in the course and scope of their employment, it should be covered. But yes, he was asked to perform services prior to his working day because he packed the equipment, transported the equipment prior to the beginning of his services, which is by definition outside of working hours.
Was it significantly outside of his working location or his working hours?
The exact time of the commute is not established in the record, Judge, although I don't know if there's a requirement for it to be significantly outside the time of standard hours, just that it was in fact outside the time of hours.
I asked Mr. Craig about ingress and egress, and he chose not to comment on it because he hadn't prepped for it, which is a legit answer. I'll ask you the same thing. Why aren't we looking at it from that perspective?
Because given the causal connection, the ingress-egress factor is well realized in the Snickers v. Finger Hut exception. There, the employee was at no greater risk on the public sidewalk from that frozen ice than anyone else. It was that causal connection and the fact that there was only one entrance that sort of absorbed the ingress-egress concept in this case, Judge.
So it's the special hazard and or street risk is basically part and parcel of it. Part and parcel of ingress and egress.
Yes, Judge.
Thank you. Would you like the opportunity to respond?
Sure. I'll move pretty briefly here. I think, at least in my review of all of these special errand cases, there is a significant temporal factor of you're being called in on your day off. Something is radically outside your normal place and hours of work. And in this case, we have someone who's coming in on a Monday morning, apparently for his normal hours. I think we have anything in the record showing that he's especially early or late or anything like that. So I think that's worth looking at. And once again, it's usually where someone's being called into work rather than returning to work after being sent out several days previously. So I think that is something to look at as you're making a decision here. So that's really all I wanted to add, at least on the special errand topic. I'm certainly open to more questions.
Thank you.
You've heard enough from me. Thank you.
Well, I think we have completed the oral arguments for today. The record is closed. There'll be a decision out within 90 days. Thank you both.
Okay. Well, thank you.
Good.